A lot of people come into our office and ask us what is the difference between a will and a trust. The legal definition of a trust is a entity that's created by a legal document which holds property such as real property and bank accounts. In reality, or in simple language, if you think of a trust as a bucket in which you place your property, and upon your passing, the trustee can take the bucket and dump it out and distribute the property without the interference of the court. It's a simpler way and an easier way for your beneficiaries to receive the property. There are two primary different types of trusts. The ones we work with most commonly are the revocable trusts. And what a revocable trust is it means that you put all your property in a trust, but you can change it because during your lifetime, you're the trustee, you control it, you control what's in it and who receives it. The revocable trust upon your death becomes irrevocable, meaning that your wishes are in concrete once you pass. An irrevocable trust can be set up during your lifetime, and it's usually done primarily for tax purposes and for distribution to future generations. An irrevocable trust cannot be changed, and therefore you have to be super sure that it is exactly what you wish to do. The primary benefit of setting up a trust is to avoid probate. By having a trust in place, the trustee is capable of distributing the property immediately upon your passing. You don't have to wait and have the court process how the property is to be distributed. It also can be used to set up for tax purposes. It also can be used to set up to enable future generations to receive your property. Oftentimes, when a client comes in, we discuss with them the difference between a will and a trust. It is important to determine which type of estate plan is more appropriate for each client's particular needs. The primary benefit of having a trust is that upon your passing, your beneficiaries will have immediate access to your funds. For example, if a case is proceeding through probate, oftentimes the bank accounts are frozen and the money cannot be distributed. This can cause great hardship for your family. It can cause great difficulties and expense as they wait for the money you intended for them to use to be distributed. The process at Z Family Law for setting up a trust is simple. You join us at our office for an approximately 2-hour meeting, and we discuss which property you wish to have placed in your trust. We review the process of transfer. We discuss with you if any deeds need to be drafted. We discuss with you whether you wish to set up any specific restrictions on the distribution of your funds. And then, approximately a week later, we bring you in for a signing ceremony and your trust is created. We also feel it is critical to follow up and ensure that your trust is funded. We will assist you with any redrafting of deeds or any renaming of accounts to ensure that your beneficiaries receive all the benefits of the trust you have established. If you have any questions at all about how to create a trust and whether a trust is in your best interest, and most importantly, in the best interest of your family, please do not hesitate to contact us. We'd be happy to help you create a legacy of love for your family.